Hi, everyone. Welcome to our parent information training. My name is Tristan Moore. I'm the care program coordinator here at Heartspring. And today we have a special guest. If you think we look alike, that's because she's my mom. This is Andrea Landreth, and she's going to tell us a little background about herself, and then she's going to give us a presentation on parents' rights in the special education system in Kansas. So there you go, Mom.
Thank you, Tristan. Like she said, my name is Andrea Landreth. I'm a school psychologist for Butler County Special Education Interlocal. I work in the Andover, Kansas schools, and I have been the parent of a couple of children with special needs first, actually. I've been a special education teacher for several years, and then now I'm the school psychologist in my schools. So I'm happy to be able to share parents' rights with you. I feel like I've seen it from all angles in different times of my life, and hopefully this will be beneficial to you today. Number one thing I think about when I think about parents advocating or speaking up for their children is communication. And if you have concerns regarding your child's education, whether they're already receiving special services or not, the first thing that I believe you should do is to talk to your child's classroom teacher. That is your first step always. If they have an IEP, your first step might be to go to their special ed teacher. It depends on how much service time they have and things like that. But I always ask the parents, have you talked to their teacher about these concerns? Because most of the time, the classroom teacher is the one who knows them best. The classroom teacher is the one who knows where they are academically and socially in the classroom. They're with them most of the time. So if you don't get the answers you need there, or you feel like things aren't changing that you think should change, then I would, if they're on an IEP, go talk to the special education teacher. They are the ones who are able to adjust things, to tell you how they're doing for them from their perspective, how they're doing on their goals. And if you don't get to where you think you need to be doing that, request a meeting with your child's education team to discuss the concerns. And the teacher or the special ed teacher might say, let's just have a meeting and talk about your concerns. This is sometimes called an IEP meeting, even though you're not rewriting the IEP. This is the IEP team for your child. And this is the team that can discuss and brainstorm ideas and try to get to where they're meeting the needs of your child that you're seeing. The evaluation process, I wanted to go over this because I know a lot of parents talk to other parents and they say, oh, your kid needs an IEP, request an evaluation. And there are actually steps that the schools take to make sure the kids don't fall through the cracks. I know sometimes the parents do need to advocate for that, and they do need to speak up and say, my kid needs to be evaluated. But the first thing that should happen in your school, if the teacher is seeing concerns academically or behaviorally or socially, they should bring them to the child study team. Every school is required to have a child study team, and this team is made up of the parent, the teacher, a special education teacher, the school counselor, the principal, and sometimes there is a teacher designee that sits in on those meetings too. So this is the first thing that happens typically if your child does not have an individualized education plan. They're brought to this team. And in this team, we meet, we discuss the concerns, we discuss the child's strengths and weaknesses. We talk about what interventions are you doing for this child at this time? And then we brainstorm ideas. So it's kind of a think tank of people coming from all different directions. The school psychologist also is a part of that team. And they put some things in place to happen over the next 4 to 6 weeks. So they start doing those interventions, and then we meet again and say, how is that going? Do we need to make any changes to that? Is this working? Is it not? Sometimes at that point, the team decides we need to refer this child for an evaluation, and then we'll start that process. However, if the parent does request an evaluation, they need to do that in writing. So that can even be an email to the school psychologist, or even to the teacher who would pass that on to the school psychologist to get that evaluation started. So submitting that in writing is your first step. Now, just because it's submitted does not mean the child will be evaluated. A lot of times we have parents say, I would like my child to be evaluated, and I have to talk to that parent within 15 days of that request to discuss our options and what we think we should do. Sometimes the team, even if they haven't met on a child, will say, I definitely have some concerns myself, and we'll move ahead with the evaluation. Sometimes my recommendation is to let us go to the child study team and brainstorm some ideas for intervention so that maybe we can meet that child's needs through regular education. We don't want to give that child more support than he or she needs, and we don't want to give them too little support. So the first thing that I usually recommend is that we let the team come up with some ideas. Parents are part of that team, and then we put those into place. And then after a month, say, okay, now what do we think? Now maybe we need to move to evaluation. If we do move to the child study team or evaluation, either one, providing documentation regarding medical diagnoses or therapies for the child is very beneficial. A lot of times in those reports from the doctors that give recommendations, a lot of times they'll say this child needs to be on an IEP. It doesn't necessarily mean they'll meet the school's criteria, but it does mean they think we should take a deeper look at that. And those diagnoses can be used as part of the evaluation to determine eligibility. The student's educational team must agree that an evaluation is appropriate, even if the parent's requesting testing. And so an example of that, when I've seen us deny an evaluation, has typically been when the student, the parent believes the student will qualify for gifted placement, and we already know he doesn't meet the criteria for a part of that, the academic prong, say, or doesn't display a need for services. Sometimes we will deny that evaluation, and we have to do that in writing to the parent. But typically when a parent requests, we take that seriously. And like I said, we either go through the steps through regular education first, or we just move to testing. This team may determine it would be most appropriate to go through the child study team process before moving to evaluation. And then the team has 15 days, like I said, in which to reply with their intention regarding the evaluation. So if you request an evaluation for your child and you get a call from the school psychologist or the principal or somebody saying, we'd really like to take them to our child study team first and see if we can get some things going that are not already in place for him. Don't feel like that's a no. That's not necessarily a no. That's just a, let's try these things first before we start pulling your child to be evaluated. We like to keep them in the classroom as much as possible. Child study teams also have different names in different schools. In my schools, we call it SBST, which is a student-based support team. I've been in schools where they call it the SIT team, student improvement team. Sometimes they're just called a child study team. So if you hear that term, that's what it's about. The evaluation report is another thing I wanted to discuss, just so you know what that entails and what you have a right to know from that report. So after the completion of a comprehensive evaluation or reevaluation, it is required that the parent receive a written evaluation report without regard to the suspected category of exceptionality. So that means we may be looking at what looks like a learning disability, but we're going to do that evaluation thoroughly so that we can rule out certain things and determine if the child qualifies and what exceptionality is most appropriate for them. If they have ADHD, for example, and it looks like a learning disability, we may find through our evaluation that really it's the attention that's causing the issues in learning. And so that child's exceptionality may end up being OHI, which is other health impaired. And so the evaluation report needs to include academics, cognitive testing. Some districts don't do cognitive testing, but around this area we do. Behavioral testing, even if it's just a summary of this is an observation I did regarding the student's behavior. needs to include observations and interviews with teachers and parents and things like that. So make sure you get a copy of your child's evaluation if that's done. Individualized education plans. The required team members at an IEP are the special education teacher, a regular education teacher, the parent, and an administrator. And actually, the parent is not necessarily required. It is required they be invited. It is required they sign for changes. But for a typical IEP that's not an initial placement, they could meet without the parent if you would rather they just go ahead and meet and give you the paperwork or fill you in. Some parents have chosen to do that. But you have a right to be given the option to be at every IEP meeting for your child. Additional team members might include the therapies they receive, like the speech pathologist, the occupational therapist, the physical therapist, things like that. Sometimes a counselors sometimes see the children like once a week or something, so they may be a part of that team as well. And they have to be listed on the prior written notice because they're kind of extra team members, or the notice of meeting. You are your child's greatest advocate and most important member of the team. So you know your child better than anyone. You have the right to invite anyone you'd like to come to that meeting. And it's your child's meeting. It's like your property, and whoever you want to share that with is up to you. We are not allowed to invite extra people without your permission. So if you have a friend who's very knowledgeable about school things and you feel like you're not, invite your friend. And if you have hired an educational advocate for your child, invite them. Anybody you feel like, therapists. We've had people, I had someone bring their mother who was a special ed teacher at one time. And so please feel free to invite anyone you want. We encourage that and welcome that because it's just more people putting their heads together to do the best for this child. And also a parent may call a meeting at any time. It's not IEP time, say it's due in October and this is April, and you would really like to meet and go over your child's goals or talk about making changes. You can call a meeting at any time. Sometimes you might amend the IEP, sometimes you might rewrite the IEP, or just discuss the IEP. But you have a right to do that at any time. And also the team members may say, I think we need to meet. I'm seeing some issues. I think we need to meet. So just because it's an annual IEP doesn't mean it has to meet only annually. Prior written notice, your school district must give you, the parent of a child with an exceptionality, written notice, provide you certain information in writing within a reasonable amount of time before it proposes to initiate or to change the identification, evaluation, or educational placement of your child, or the provision of a free, appropriate public education to your child. That's a lot of jargon, but basically it means that you are to receive a prior written notice if we are going to say your child's been receiving services under developmentally delayed. That's a temporary label that has to be changed by a certain age. State of Kansas says age 10. The districts sometimes have a lower age. So changing that exceptionality from, say, DD to LD, a learning disability, or to autism or something like that. You have to sign the prior written notice stating that you agree for that change. Evaluation, you have to give your signed consent to evaluate a child, whether it be an initial evaluation or a reevaluation. Also, they cannot change the placement of your child. For example, if they decide to start pulling your child into the resource room for 30 minutes a day for certain instruction, rather than keeping him in the classroom during that time, you have to sign saying you're okay with that. And then also, if you feel like your child's not receiving a free, appropriate public education, and changes need to be made for that, then you have to sign for that as well. Refuses to initiate or to change the identification, evaluation, or educational placement of your child. So if the district sends you a prior written notice and you don't agree with it, or if they send you a prior written notice for an evaluation and you do not want your child evaluated, there is a box that says, I do not give consent for this. So that is something you'd have to sign as well. Now, all of these signatures I'm talking about can be done electronically. I mean, since COVID's happened, we started doing all of that electronically. We still are able to accept electronic signatures. So don't feel like you have to be in person to get something done. They can definitely do that through email or sending things home with your child, whatever you prefer to do. Notice in understandable language, we do have parents who don't speak English well. It's not their native language. We are required to give IEP documents in your native language. The Parents' Rights booklet is available in your native language. And through Butler County, we have the option of many, many languages to change our forms. So if you have gotten one in English and are struggling to get through that, please speak up and tell them, I need this in, this other language is actually my native language. I need it in this language. They should know that already. Just getting started in this process, they should know that, but please say something if you need it in another language. Also, don't be afraid to ask questions if you do not feel fully understand. Remember that the people in the schools use this jargon all the time and sometimes forget that you don't live in their world of education. I mean, if I went to a meeting with a bunch of doctors and they started talking medical terms, I would probably feel like a lot of parents do sitting in our IEP meetings. So having been the parent first for me, I feel like I do a pretty good job of speaking in terms that the parents can understand. But if you do have questions or you say, what does that acronym mean? Sometimes at an initial evaluation meeting, they may not even know what IEP means. So be sure to ask questions if your team does not clarify things well enough for you. A lot of times the paperwork has a lot of extra wording. You might ask, what does this mean? Is this pertinent to what the form is about? Ask questions and make sure you fully understand, and don't feel dumb about that. Because like I said, we know you don't live in the world of education. You don't use these terms on a daily basis like we do. So please feel free to ask questions. Parental consent. This is what parental consent means. You've been fully informed of the action proposed. You know exactly what they're asking you to sign. You understand and agree in writing to this action. You understand that the consent is voluntary on your part and that you may withdraw your consent at any time. So if you wish to revoke consent after your child has begun receiving special education and related services, you must do so in writing. The school district is not required to amend or change your child's educational records to remove any references that your child received special education and related services after you withdraw, after the withdrawal of consent. So you can stop services at any time by requesting that in writing, but that record is going to stay the same. You can't change their record, what's happened in the past. And that record, though, is confidential. And you have the privilege of seeing that paperwork, but anyone else outside of that team of people does not have the privilege to see those records. So parental consent is required for an initial evaluation. So consent for evaluation is not consent for services. I make sure parents understand this. A lot of parents are hesitant to have their child evaluated because they think that just automatically means they're putting into special education, but it doesn't. It's a separate decision. The school district must make reasonable efforts to obtain consent for evaluation. So if the team decides that we'd like to move forward with testing, and I send home the paperwork to be signed for evaluation and get no response, I have to keep trying a few times, a couple of different ways. We have to use a reasonable efforts to obtain consent for evaluation. So if you feel like you're being pestered over that, please let them know, I'm not interested, sign I'm not interested, but they do have to keep trying to get that consent or to get an answer whether or not the parents want the testing done. So whether or not you give or deny consent does not impact the services or benefits your child is receiving through general education. So if you say, no, I do not want them tested, it doesn't mean they're going to be pulled from their reading intervention they're getting through regular education. They'll still receive the same benefits that they receive through general education. You have to give consent for initiation of services. Services cannot begin without your written consent. The school district must make reasonable efforts again to obtain consent for initiation of services. So sometimes we're wrapping up an eval and parents are not responding. We have to keep trying to get a hold of them, to share that information with them from the evaluation, and to see if they would like to continue to receive services or not. Also need parental consent for reevaluation. The school district must make a reasonable effort to obtain that consent. Again, the school district may use existing data or assessments given to all children without parental consent. So a lot of times when we're in that child study team, we want to look at data to see how they're doing, and we will look at the same tests that they're given to other children. There are some things that they do, like in our district, they use the STAR testing for reading and math, and that is given to all of the children. So we can use that data to see where they're at compared to their peers. And then material change in services or substantial change in placement. So like I said before, if they're going from being in the classroom receiving services to being pulled out into the resource room to receive services, you have to give consent for that. If it's a material change of 25% increase or decrease in frequency or duration of services, or if it's a substantial change in placement, which is the movement of a child to a less restrictive or to a more restrictive environment for more than 25% of the school day. And even though if it's less than 25%, we still have to send you that notice. You don't have to sign it, but if they're amending the IEP, which they would need to do, you would sign the amendment for the IEP. So even if they don't require service on that prior written notice, they still have to discuss it with you. They still have to send you that paperwork. They still have to make you aware. And if we're changing the IEP, you still have to sign the amendment. Revocation of consent. So I just put in this blurb here from our parents' rights document from the state of Kansas. Parents have the right to revoke consent to particular services or placements if the IEP team certifies in writing that the child does not need the service or placement for which consent is being revoked in order to receive a free appropriate public education. So usually if we feel like a child doesn't need services anymore, we will recommend doing a reevaluation to see if they still qualify. Sometimes the IEP has gotten down to just one goal, or maybe they're on monitor and everyone on the team believes that they don't need services anymore. You have the right to sign that and say, yes, let's take them out of special education. However, if they're receiving services and the team believes they need those services, that you as a parent say, for instance, if they're getting physical therapy through school, and also outside of school, you as a parent can say, I think it's too much for my child to get it at school and outside of school. I would like to revoke my consent for that PT service on their IEP. The school cannot keep that service if they believe they need it. They have to honor your request. If you submit it in writing, I want them dismissed from PT, they will take PT off of the IEP. And so you have the control over the services your child receives. Even if the school says, we really believe we need to keep doing this, you can say, I don't think it's necessary. And they will take off the service. Independent evaluation, educational evaluation. This is something I've dealt with in the last couple of years, actually. This is an outside evaluation. An IEE is an evaluation conducted by a qualified examiner who is not employed by the school district responsible for the education of your child. You have the right to obtain an IEE of your child if you disagree with the evaluation of your child that was obtained by your school district. So if if the school did a reevaluation, say, on your child, and you felt like it didn't give enough information for them to determine the needs of your child and how to meet them at school, you can request an IEE. The school district must provide you with information about where you may obtain an IEE and about the school district's criteria that apply to independent educational evaluations. And so when an IEE is requested, the school district must either file a due process complaint, which is a legal complaint, or provide an IEE at public expense. So if they believe your concerns are legitimate and that it would benefit you and your child to receive an outside evaluation, they will pay for that evaluation. If they believe there's no way an outside evaluation could give more information than the school has already provided, they can file a due process complaint. Like I said, this is a legal complaint. If taken to due process and found that the school district's evaluation is appropriate, you still have the right to have an IEE, but not at public expense. If an IEE is requested, the district is allowed to ask why they oppose their evaluation, but the district may not require an explanation and may not unreasonably delay a response. So they can ask you why. You don't have to say why. Typically, parents do. They discuss their concerns with the team, but the district has to let you know if they will pay for it or not within a reasonable amount of time. They can't delay that and put that off. You are only entitled to one IEE each time your school district conducts an evaluation, and you always have the right to have a parent-initiated evaluation completed, whether that is paid for by the school or paid for by you. Now, I've seen this come up a couple of times. I've seen it rejected. I've seen it followed through where the district does pay for it. Also, another option if this happens is for another reevaluation to be completed, possibly by another school psychologist with the team or with some other specialists within the district. So you also have the right to say, let's do another reevaluation and I want these areas looked at in addition to what's already been done. So it's not just black and white really with that. You can, and then after that second reevaluation, you can say, okay, I just still don't feel like we have enough information. I'd like an independent educational evaluation done, and go from there. Accessing your rights. You are permitted to inspect and review any education records relating to your child that are collected, maintained, or used by your school district within 45 calendar days after you have made the request. Now, if people request to see their records from me, I just get those to them as soon as possible. I don't know that anyone would wait 45 calendar days unless their records department or something is really backed up. But if you don't have it within that 45 days, there's a problem. The district may charge a fee for copies of your child's record. However, you still have the right to inspect and review the records at no cost. And in our co-op now, or in a local, we have everything digital. So we've scanned in all of our documents. They would likely just send you those electronic files for your records. Records are kept in the district for 5.5 years. You have the right to ask for certain records to be destroyed prior to this. So if your child graduates, you want those records destroyed in the next year, they can destroy those records. However, a permanent record of your child's name, address, phone number, grades, attendance records, classes attended, grade level completed, and year completed may be maintained without time limitation. So that's just a school record. Like our schools use Power School. They've got all that information in there. And it could be in there a lot longer than the 5.5 years. It's not part of special education record. So filing a state or due process complaint, I mentioned due process earlier. You may file a complaint with the state if you believe the school district has violated a requirement of Part B of IDEA. You or the school district may file a due process complaint on any matter relating to a proposal or refusal to initiate or change the identification, evaluation, or educational placement of your child, or the provision of a free appropriate public education or FAPE to your child. The procedures for filing complaints can be found in the parents' rights document and received from your school district at your child's IEP, which you received at the IEP. You should be given a parents' right document or offered one every time you meet annually for the IEP. So the difference is a state complaint is you make a complaint to the state and they send their investigators to come to the school and see if they believe that the child is getting their needs met through IDEA. A due process is actually like a court hearing. It's a legal action, and it can be filed. Due process can be filed by the parent or by the school district. This doesn't happen very often. Typically, they can work things out within the district, but that is something in place to help you make sure that your child's rights are there. So for a state complaint, the violation that occurred must be within 1 year of the filed complaint. And for due process, the complaint must allege a violation that happened within 2 years of the filed complaint. And these are drastic measures, like I said, but they are in place as safeguards. The school district must inform you of any free or low-cost legal and other relevant services available in the area if you request the information or if you or the school district file a due process complaint. So you can get that information from them. So in summary, I just want you to remember a few things. That communication is key. A lot of people are a little afraid or intimidated to go to the teacher or to go to the team with their concerns, but that's what they want you to do. They absolutely want to work with you as a team, and please keep those lines of communication open with their teacher. Go to your child's teacher first with concerns, if you can. I have seen people jump to the principal or jump to the school psychologist for something that could have been resolved if they had just talked to the teacher or the special ed teacher about it first. Remember, your child's IEP team wants what is best for them. And they really do. The schools I have worked in, those IEP teams, they really do want the very best for your child, and just keep that in mind. Don't be afraid to speak up. You know your child better than anyone, and it is your right to speak up. So
perfect. Thank you so much. That was really digestible, I guess, for me, which was really cool. So thank you so much.
Good. You're welcome.
Anyone who is watching and is interested in learning some more about IEP, we do have about an hour-long presentation by Megan Sweat, who's our division director of the school here at Heartspring. She did an IEP advocacy presentation before, so if you're interested in learning some more, you can go check that out on our YouTube page. And again, thank you so much, Mom. And I hope everyone learns a lot from this. So thank you.
You're welcome.
Have a good day.